first just approach with?
Yeah.
Sir, I'm going to show you what's been marked as State's Exhibit number 11 for identification purposes only. And I just want you to let me know whether you're familiar with that document.
Yes, sir, I am.
Would it be fair to say that's in terms of your file on this case or parts of it?
Parts of it. This would be the reports in that file.
So, are there other information that pertain to this case that would not be included in that file?
So there would be attachments that are referenced within the reports that would be attached to that file as separate documents.
Would all those documents would have been turned over to the state?
Yes, sir.
Would that include things like the evidence law?
It should, yes, sir.
Would that evidence law, would that be a part of the exhibit that I just gave to you?
It would be, yes,
It
sir.
would be inserted here?
Yes, sir.
Could you just kind of thumb through it and see if you can find it? Could you look for it?
See the evidence log?
Yes.
So the evidence log itself will not be in this packet, no.
Could you briefly, I'm starting here, but I'm going to go back, but with reference to the evidence law, what is that exactly? What is, could you kind of explain to the jury what is a function of the evidence law?
Yeah, basically, an evidence log is just a document that it documents what evidence is discovered and what evidence is collected, date, time, who recovered it, and so on.
Would it also give you an indication in terms of which officers were at a particular scene?
It could, yes.
When you have, say, crime scenes, a crime scene normally taped off, say, evidence tape to tape off a crime scene. Is that normal procedure?
Yes, it is.
In, say, for instance, in a case where you're, say, seeing that subject to like a search warrant or something like that, would you want to put evidence tape around a particular scene?
Yes, sir, you'd want to secure that scene. That's correct.
Okay. Now, was that done in this case?
Yes, it was.
Okay. Do you recall do you know which officer, say in the Fowler location?
I'm sorry, Mr. Cox, could you
The
speak?
Fowler location, do you recall which officer would have been responsible for placing crime scene tape?
No, sir, I don't recall.
If once that tape is, crime scene tape is established, if a person goes into that scene, would that person have to be listed on the crime scene log?
That person should be listed on the crime scene log, yes, sir.
And which would also should indicate when that person entered the crime scene and also when that person exited the crime scene, correct?
That's what should happen, yes, sir.
With reference to crime scene log in this case, you said it's not a part of your State's Exhibit number 11?
No, sir.
did you review that information in preparation for your testimony?
Yeah, you're asking about the crime scene
Crime
log?
scene log, did you look at it, did you review it?
No, sir. No, sir.
Okay, so there were some items with reference to this case, your testimony that you didn't review before in preparation for your testimony.
That's correct.
Okay. Finally, the crime scene log in this case, do you know whether it was 1 page, 2 pages, 3 pages, do you know?
I couldn't tell you, no, sir.
Okay. If you, with reference to State's Exhibit number 11, if you look through it, could that refresh your recollection to how many pages compose the crime scene log in this case?
I don't believe it would. No, sir.
You didn't put it down. You didn't write it down in there anyway?
No, sir.
Now, this particular case was actually assigned to you, correct? In terms of an investigation, eventually this case was assigned to you, correct?
Correct.
Okay. And you're you testified earlier, you're a Texas Ranger, correct?
Correct.
And when a case is assigned to you, you become like the primary or the lead law enforcement officer with reference to as pertaining to this case, correct?
Correct.
So it's fair to say that in terms of information as situations develop, even if you get information with reference to work from other officers or other rangers, it's fair to say that that information eventually flows to you, right?
It should, yes, sir.
It should. And it's fair to say, is it fair to say that one of your jobs would be to compile all the evidence in a case, correct?
Correct.
And that becomes, I would say, a master file for you, and all the information that has been collected from this case. You should have the ability to access that information. You're basically responsible, correct?
That's correct.
And it's fair to say that if, say for instance, excuse me, if there was, say, additional information that was needed, say for a witness to be contacted or to look for, say, additional evidence, if you were not able to do it yourself, you could actually request other rangers or other law enforcement agencies to assist you, right?
That's correct.
Now, do you recall when you first became involved in this case in terms of the approximate date? When did that happen?
That was in May of 2021.
And was the case assigned to you by someone? Is there a procedure how you would be the lead on a case and not someone else? How does that work?
So I wasn't really assigned the case, if you will. The case was brought to me is how I became the lead on that investigation.
Okay. When you say brought to you by another ranger or another police agency?
Right, so as we discussed yesterday, the information reference a missing person, the possible murder, was brought to me by Special Agent Nava with DPS.
Now, excuse me, once that occurred in this case, would be your first thing to do is to try to develop in terms of either a strategy, or do you just at that point try to review information and make a determination in terms of how you're going to say attack or address trying to resolve the case? How is that?
So it depends on a case-by-case basis. In this situation, there was an individual that was a witness that was interviewed that provided the initial information to start that investigation.
So it started out in this case with the interview process of you with a witness?
Correct.
Okay. Now, do you recall, with reference to that first witness, is it someone that you interviewed yourself, or was that person interviewed by another officer?
So myself and Agent Nava interviewed the initial witness.
Okay. And just to be clear, Nava isn't actually he's DPS, he's not a ranger, correct?
He's not a Texas Ranger. He's assigned to the Criminal Investigations Division.
Okay. Now, eventually, did you have a partner, or did you join with someone and have someone join you from a ranger from the Texas Rangers that became like your assistant in terms of this case?
So at some point, I requested the assistance of Ranger Pettis.
Pettis. Do you recall whether that was within a week, 2 weeks later, or?
I don't recall, no.
As a Texas Ranger, and you have to be certified as a peace officer, correct?
That's correct.
Do you use a body cam? A body cam?
No, sir.
That's something that's not issued to Texas Rangers?
No, sir.
Other agencies, they have them, correct?
Yes, sir.
What, is there a reason?
Bless you.
Is there a reason that Texas Rangers don't have them?
I don't know if there's a reason. Really, so we're not, as Texas Rangers, we're not out making contact with the public every day. We're not out making traffic stops and making contact with citizens every single day. The majority of the contacts that we have are going to be in interview rooms like y'all have seen, and the majority of those interviews are all on video and audio recorded.
So in terms of the first witness that you contacted in this case, was that witness interviewed on videotape?
Yes, sir, he was.
And that videotape, that video interview was conducted where?
At the Texas Department of Public Safety regional headquarters here in San Antonio.
And did you, in terms of all the witnesses that you talked to with reference to this case, were their statements all done on video?
I don't know if all of these statements were taken on video. If they were not recorded on video, then there should be an audio recording of those interviews.
So when you say audio recording, you would have a tape recorder with you?
Correct.
And all tapes would be given to the state, correct?
Correct.
Now, as you, Ranger, as you start developing, I guess, leads in this case, did there come a time when you you decided to have not necessarily a conference, but you assembled officers or rangers, law enforcement from different areas, and you had a kind of like a session where you talk to them and you get a briefing?
Yes, sir.
Okay. Was that on one occasion or more than one occasion?
I believe that was on one occasion.
Now, do you recall when that briefing occurred?
I believe it was on the day that the search warrants were executed.
And that also would have been the day that my client's vehicle was stopped, correct?
Correct.
Now, in reference to that briefing that was given, do you recall how many law enforcement officers that or agencies that you notified and requested their presence to?
I don't recall. It was a handful, several agencies.
Would that be reflected in your in state decision 11, your report?
No,
Who
sir.
sent the information?
No, there's nothing in the report reference the operational briefing, no.
Do you remember where that briefing was held?
It was at the DPS office here in San Antonio.
And obviously that briefing wasn't recorded.
No, sir.
Your notification to agencies or officers with reference to that briefing, was it done by text message? Was it email? How do you notify?
I couldn't tell you. It could have been through text message, could have been through phone calls. I could have notified some agencies. Ranger Pettis could have notified some agencies. I don't recall.
Okay. So are you saying that Officer Pettis was a part of the process of notifying agencies?
He could have been. I don't recall.
How many officers attended that session?
I couldn't tell you.
You don't
A
know?
lot.
I'm sorry?
A lot.
A lot of them? Was it, you think, more than 10?
Yes.
How long did the session last?
I couldn't tell you that either.
Did you have like an itinerary in terms of the things that you made them aware of? Did you have a list of things that you went through with them?
Yes, sir. So basically, it was an operational briefing, right? So we were going to execute these search warrants at different locations. So all these officers are brought up to speed on the case up to that point. Let them know what has happened, what we're doing, and why they're there, and then they will be given assignments from that point. That's all the briefing was.
Do you recall, say, how many Texas Rangers were at that meeting?
I do not.
Was Ranger Pettis at that meeting?
Ranger Pettis was, yes, sir.
So, meeting your itinerary in terms of the things that you discussed with them, you didn't write any notes with reference to that?
Everything that would have been discussed at the briefing is in the details in my report.
Is that a report, a part of State Exhibit number 11?
Right. So again, the briefing is not discussed in State's Exhibit number 11, but the details that are in my report, that is what was discussed at the briefing.
So at the briefing, did you give any assignments to any of the officers that were there, things that you wanted them to do?
There are things that I wanted them to do that needed to be done, and I don't know if I necessarily, well, I know for a fact I didn't make all of those assignments. They may have been divvied up, and supervisors of deputies or officers that were on scene made those assignments. I don't know how all that happened.
Okay. So you were conducting the briefing, correct?
Yes.
Do you recall what assignments you made?
I don't recall.
And that's not in your notes either.
No, sir.
Do you recall whether you, with any of these assignments, did you give any officers any assignments as to look for a vehicle, a type of vehicle that was the subject matter of the investigation?
Yes, sir.
Now, you remember that?
I do remember that there was a specific vehicle that we were looking for, yes.
Do you remember whether you gave any particular assignments to any officers or agencies reference to that particular vehicle?
I don't remember any specific instructions reference that particular vehicle, no.
So it's fair to say you remember having a briefing, correct?
Correct.
But as to what actually happened during that briefing, you don't recall it?
No, it was giving the officers that were there that had no knowledge of the case information on the case so they knew what they were doing and what they were looking for and why they were there.
Do you remember ever giving any instructions about a particular vehicle that was supposed to be traveling a certain road, and to have that vehicle strike it, and to find probable cause to stop it? Ever given any instructions like that?
So I do remember that happening. Whether I gave those instructions or somebody else gave those instructions, I don't know.
In your testimony, there's nothing in State Exhibit number 11 or anything else that you wrote down of that briefing that you could go back to and refresh your recollection of what happened and how it happened?
I could go back and look.
Okay. Do you have that information right now to look through?
State's Exhibit 11, I got it right here.
Okay, look through it.
Okay. So detail 7.3 mentions the traffic stop of the vehicle.
But does it mention anything about what you said or may have said to officers at the briefing?
No.
No. Now, eventually, it's fair to say that my client's vehicle was stopped, correct?
Correct?
Do you recall whether you made, whether you were notified of when that vehicle was located?
At some point, I was notified that it was located.
Do you recall whether you went to the location of where that vehicle was stopped?
I did not.
Do you recall where you were when you got the notification that that vehicle was stopped?
I believe I was at the Lucky Road address.
Now, the crime scene law for the Lucky Road, is that in your packet?
It is not.
Do you remember seeing it? Have you ever seen that? Do you remember reviewing it ever?
It's been a while if I've reviewed the crime scene log.
So if it's not in your report, where would it be?
It would be included in the attachments included to my report.
Do you have a copy of those attachments?
I do not have a copy here now.
Where are they located?
They would be included with the file.
Okay. So your master file is where?
So everything that I have was turned over to the prosecutors. So where those attachments are, I don't know.
And you don't keep copies of them?
Yes, I keep my own copies, yes.
Correct. Okay. So where would your copy?
My copies would be stored at my office in Seguin.
So that file that you have in Seguin, your testimony is that you never went back to review it in preparation for this case?
So I didn't specifically review a crime scene log, no.
You know what I'm saying? The file itself, you review it. The file in Seguin, your master file in Seguin, have you ever reviewed that file in preparation for your trial testimony?
The entire file, no. I reviewed State's Exhibit number 11, the reports that I made reference this case.
So you don't recall whether there is a crime scene law for the Lucky address?
There should be a crime
There
scene
should be.
log, yes.
Now, do you recall ever giving any officer or any ranger instructions in terms of if the subject that we're looking for, my client, if he was, say, arrested, that you wanted an opportunity to question?
I don't recall if that conversation was had. I mean, I'm sure it was because that's what happened, but I don't recall specifically that conversation, no.
So, is it reflected in your report the approximate time my client's vehicle was stopped?
Let me take a look. Again, detail 7.3 report indicates that he was observed driving the Yukon at 5:36 p.m.
And you believe that at that point you were at the Lucky address, correct?
I could have been on the way. I could have been there already. I don't know.
Now, you indicate that you executed a search warrant at that location, correct?
Correct.
Okay. Do you recall what time you arrived at that location?
I don't recall.
Okay. Do you recall how long you were at that location?
I do not.
Don't recall that. Do you recall what time you left that location?
I do not.
And none of that is reflected in your report.
I can go back and look and see.
Would you please?
So it had to have been getting late in the day, closer to dark. Detail 7.12, due to the time of day and limited daylight, it was decided to resume the execution of the search warrants at both properties the following day. So I would assume it was late in the evening sometime.
What, late in the evening is what time? I mean, do you know what time?
You could ask 12 different people, they might give you 12 different answers.
Okay. 12 is good. I like to correct one if you can. So you don't know what time you left?
Whatever, I mean, close to dark.
Close to dark. So when you left that address, Lucky, do you remember where you went after?
To the Bexar County Sheriff's Office.
And what time did you get there? Do you know?
I couldn't tell you that either.
Now, once you got to Bexar County Sheriff's Office, did you meet up with other officers or Ranger Perez, or what did you do?
Met up with other officers there.
You remember who you met?
Ranger Perez was there. Ranger Wright, maybe. Ranger Benoit.
Okay. So at this point, when you arrive here, do you meet immediately, do you know that, that my client was at the jail?
Yes, I did.
Okay, you knew he was at the jail.
Yes, sir.
Do you know whether, right, you plan, is it your plan to try to interview?
Yes.
Okay. Once you go to the jail, do you go and try to interview him at that time?
You're asking that as soon as I got to the jail?
Yes.
No, sir.
Okay. And do you have any idea at that point whether or not he's waiting for you or not waiting, he's being held for you, or whether he started the magistration process? Do you know?
I don't believe I know at that point, no.
Do you inquire at that time? When you get to the jail, do you inquire as to his status?
I may have. I couldn't tell you one way or the other.
It is not in your notes here. It's not in your report, correct?
Correct.
Okay. Now, so you get to the jail and you meet up with the other officers. You said there was maybe two other rangers that were there?
Yeah, there could have been, yes.
Could have been any other officers, like Bear County or anybody?
Yes, sir. There were some Bear County personnel there.
Okay. And when I say there, in terms of when you have your little meeting with them, at that point, do you conduct some type of search of the vehicle?
Yes.
Okay, you talk about processing of the vehicle, correct?
Yes.
How many officers, rangers, was involved in that process?
Let me refer back to my report. I show Ranger Jesse Bettis, Ranger Kevin Wright, and Ranger Condi Benoit, along with Bear County Sheriff's Office crime scene deputies, Barbosa and Anderson.
So, so my count is maybe, what, about 8?
I'll show myself, Ranger Wright, Ranger Benoit, and 2 deputies.
So, 7
Or 5, 6.
6. Now, so your testimony that you needed 6 people to process that vehicle.
I wouldn't say that we needed 6, but the more you have, the quicker it goes.
So let's say if you could bring 14 people,
14 making in the way.
it'd be too many.
Yeah.
So it's fair to say that if it needed be, you could have had, say, 4 people involved in the processing of the vehicle, and you would have 2 to go in and interview, if you were able to interview somebody and do the interview, right?
Right. That would be up to the lead investigator, though.
Who's that?
That would be me.
That would be you. So you could have made that call. You could have made that
I could have made that call, yes, sir.
Okay. You didn't make that call.
No, sir.
And it's fair to say that you didn't even check to see the status of the of my client.
Other than I knew he was at the jail, I don't recall checking on his status, no.
No. So, how long did it take you all to process the deal?
I don't recall.
All right, so it's not notated when you started the process, correct?
I can go back and check as well.
And when you go back and check, see if you can determine whether when you arrived at the jail were they in the process of processing of the vehicle, or were they just kind of waiting around for you to get it?
Okay.
Go ahead and.
So it does not indicate what time we started processing the vehicle, nor does it indicate whether they started, but they hadn't started the processing of the vehicle until we got there.
Until you got,
Correct.
when you say we got there or you got there?
I got there.
Okay, you weren't riding with FedEx, were you? You were
No, we
in
were in separate vehicles.
separate vehicles.
Correct.
So eventually, after processing the vehicle, and photographing and all those types of things, after everything else is done, now you go to, at that point, do you go to locate my client?
Yes, sir.
Did, excuse me, did someone lead you to the room he was in, or did you kind of find it yourself?
Somebody definitely led me back there.
And I believe in the video that you testified that you seen about the process, you walk into the interview room and you were with two other, with another ring.
Yes, sir. Yes, sir.
And with the other person was who?
Deputy Arevalo, so I'm not sure his last name.
Now, do you recall whether, when you get to the interview room, whether there's a deputy stationed outside of it?
I do.
You don't remember who that deputy was? Do you know him?
I don't remember who that was, no, sir.
Okay. Did you inquire of anyone before you went into the room, whether or not anything about my client's condition? Did you talk to anybody about his condition?
I don't recall that, no.
No. Were you ever made aware that he had been placed in another interview room and had to be moved to a second room?
I don't recall that either, no.
Now, you've been a certified peace officer for how many years?
Since 2006.
2006. You're familiar with the booking process, correct?
Yes, sir.
person's arrested for a crime. They're booked in to jail. And normally they would go see a neutral magistrate, correct?
Correct.
It's fair to say that once that person's in custody, they don't decide where they sit at or where they're placed at. It's the deputies or persons that operate the jail, they make that determination, correct?
That's correct.
So if they put you in a room, you pretty much stay in that room until you're removed by staff, correct?
Correct.
And if it's a situation where you want to have a drink of water, you don't get that drink of water unless the staff allows you to do it or bring it to you, correct?
I've never worked in a jail, so I couldn't answer that, but I would say probably so.
Probably so. You know something about the magistration process, correct? Do you know anything about the certified officer? You know about the magistration process?
Yes, sir.
Correct?
Yes, sir.
In the magistration process is where the judge,
Yes, sir.
the magistrate judge, will actually go over the rights of the person that booked it, correct?
Correct.
Now, before you went into that room, started this interview with my client or that process, did you inquire of anyone in the jail staff, staff or the officer that was outside the door, whether my client had seen the judge, had been magistrated by him?
I don't recall that conversation taking place, no.
Did you check to see whether he had been magistrated prior to you getting it?
No, sir.
It would be fair to say that if he had been magistrated by a judge prior to your getting it, it could be a situation where some decisions could have been made between him and the magistrate that you didn't know about.
And Judge, that's going to call for speculation.
But you never inquired, correct?
Correct.
Now, you enter the room, my client is in the room, interview, correct?
Correct.
At that point, do you have any idea as to how long, how many hours he had been in the interview room?
I would say I had an idea, but I don't know exactly how long he had been in there.
Did you ask any, say that deputy in the front, how long had he been?
No, I don't recall asking that question.
So you get into the interview room and do you recall whether you or anyone else asked my client questions are you under the influence of anything? I remember asking any questions like that.
I believe it was myself that asked him if he needed anything to eat or drink, but I don't recall asking anything about him being under the influence. No.
So the answer to the question is no.
No.
In terms of a statement or trying to get a statement from some person, would it make a difference to you if that person appeared to be or was under the influence of something like, say, maybe drugs or alcohol? Would it make a difference to you?
On whether or not
You took a statement from him?
I would still take a statement, yes.
Even if he was under the influence of drugs or alcohol?
Yes.
Now, in part of your training as a peace officer, you're trained in the method of taking statements, correct?
Correct.
And taking witness statements, correct?
Correct.
And also taking statements of a person that could be accused of crime, correct?
Correct.
And as a part of your training, you're trained, and you can correct me if I'm wrong, that if the person is under the influence of drugs or alcohol, you still try to take a statement.
So I think each individual officer can make that determination on their own. At that point in time, I don't think there's any way you could definitely determine that a person is under the influence of anything.
You could ask him.
You could ask him.
So, in this case, my client's case, you don't read the Miranda to him, correct?
I do not, no, sir.
Okay. Was that assigned to a radio prayer test, or that something that you all agreed upon before you went into the room?
So Ranger Pettis was going to initiate the interview, so Ranger Pettis was going to read the Miranda.
So, the warnings are read, correct?
Correct.
And in terms of reading from the card, if you have to guesstimate, it wasn't like, it didn't take him 5 minutes to do it.
To actually read it?
Correct.
Correct.
Less than a minute, probably.
Maybe so.
Maybe so. So as it read, it's fair to say there's never any explanation of anything. You read, you try to get, it was read, you got an indication, you go to the next line. Is that what happened in this case?
I'd have to watch the interview again to see exactly how it was read and how he responded.
Yes, Judge, just very briefly, I'll reiterate. Ranger Peters, okay, you testified during cross-examination just now that the vehicle that Andres Tarnava was traveling in, that red GMC, was first spotted about 5:30 p.m. according to the report on that day.
Correct.
I'm imagining shortly thereafter the traffic stop must have occurred.
Yes, sir.
Now, from what the jury has seen in that video of the interview, you know it's recorded and you've seen, he was entered into that room at approximately 7:40, 7:50 in the PM, right?
But I don't recall the timestamp.
If that's what the timestamp said, you wouldn't have any reason to doubt.
No, sir.
Okay, so between the hours of 5 and 7, we can make the extrapolation that he traveled from there to that room. Maybe he was in another room before, who knows, right? By the time that investigators, yourself included, come into the room, it's about 11:50 in the PM. Well, if that's the timestamp on the video, no reason to doubt it.
That's the timestamp. Yes.
Okay, so we're looking at from vehicle being spotted at 5:30 to 11:50, about a 6-hour period.
Correct.
No reason to doubt that.
No, sir.
Okay, so we know that he was in custody for about 6 hours prior to the interrogation.
Yes, sir.
Okay. Ranger Peters, you were asked questions at length by defense during cross-examination regarding the booking process, magistration, if the defendant had been taken before a magistrate, things like that. You told us you're a peace officer, correct?
Correct.
And you've been a peace officer since 2006.
Correct.
So you are familiar with the duties and responsibilities of peace officers according to the Code of Criminal Procedure.
Correct.
Okay, so let's talk about the duties of a peace officer when a person in custody has to be taken before a magistrate. What do you know about that?
Once a person's arrested without, I believe the way it's worded is unnecessary delay, they have to be taken before a magistrate, but it can't be any longer than 48 hours.
Okay, was it anywhere close to 48 hours in this case?
No, sir.
Now let's talk about unreasonable delay. Remind us, Ranger Peters, why there was a delay in this case.
So if you'll recall, we relocated to the sheriff's office to process Mr. Tarnava's vehicle prior to conducting the interview with him. So the only delay that was incurred was during the time that we were processing the vehicle.
And why is it important for an investigator to do those things prior to engaging with a suspect?
So I didn't make the decision to go immediately to the interview with Mr. Tarnava because I wanted firsthand knowledge of any evidence that was located inside of his vehicle prior to going into that interview with him.
Okay. Another question, my last series of questions, I guess, Ranger Peters, is intoxication. Defense counsel was asking you about whether or not Mr. Tarnava could have been intoxicated. While you were in the room with him, did you perceive any signs of intoxication while he was answering questions?
No, I didn't.
Was he able to coherently and intelligently respond to any questions that were asked of him?
Yes, he was.
Was he giving off any signs that he might be slurring his words or not understanding what was being spoken?
No, he wasn't.
Thank you, Rick. No further questions.
Anything further, counsel?
Yes, one more. So you wouldn't suggest, prosecution mentioned 48 hours. So are you basically saying that, keep someone locked up in the room 48 hours, that's reasonable? It was 48 hours, that's the maximum.
That's the maximum, yes.
So you're not suggesting that, would be fair, well, we won't keep them 48?
I'm sorry,
I'm sorry, we wouldn't keep them 48, we'd keep them 24 hours in a small room locked up, right? Is that reasonable?
To keep him 24 hours
24 hours.
without reason? No, I wouldn't say that's reasonable.
In the room, it's not a large room, correct?
No.
Right. And you testified, you never questioned or even inquired to whether or not he was in another room, a separate room, before he was placed in the room that you interviewed in, right?
Correct.
Okay.
No further questions.
All right, Ranger. Take care of yourself. Stay well, will you?
Thank you.
Next witness.
Your Honor, the San State would rest.
I'd like to make a motion outside the purview of the jury.
You got it. Take the morning break, ladies and gentlemen. All right for the jury. All right, have a seat, everybody, please. Ladies and gentlemen, I apologize for the delay. State you had rested your case. Defense, did you wish to give an opening statement?
We waive opening statement.
All right, call your first witness then, sir.
You called me Dr. John Sabello.
Okay, and ladies and gentlemen, as you will notice, the doctor is back in North Texas. He's going to offer some testimony. The defense is calling him as a witness, and Mr. Tarnava has agreed that we can do it by Zoom. So that's the only kind of situation where we can do that, because you have a right to confront any witnesses against you. But they've been kind enough to agree to be able to do it by Zoom to save the doctor a flight back here for some testimony that the defense wanted to elicit. Okay, just so you know where we are. All right, doctor, can you hear me? It's the judge.
Yes, sir, I can hear you.
All right, nice to see you again. Remember that you're still under oath, okay, sir?
Yes, sir.
All right, thank you, sir. Go ahead, Mr. Cornelius Cox.
Doctor, can you hear me okay?
Yes, sir, I can.
Okay. And you're the same Dr. Sabello that testified on yesterday, correct?
That is correct.
I just want to ask a few questions of you, because on yesterday, during your testimony, you spoke about procedures that you used to come up with the conclusions that you made about the items, the fragments that you testified about, correct?
Yes, sir.
Okay. Now, there was a question that I asked you on yesterday, reference to your examination of these items, these bones, and you asked a question as to whether or not, as a part of the procedures that you perform, whether you're taking X-rays of these items. You know that?
Yeah, I believe you had asked, if I remember correctly, you had asked what the typical procedures were that we would do. And I had said something to the effect of providing a general inventory, collecting photographs, and collecting X-rays. I think that was something that I offered.
Correct, okay. And I think it could have been on a follow-up, that there were some testimony by you about whether or not you had X-rayed these items, correct?
Correct.
And do you recall whether you indicated in the affirmative that that may have been done or was done?
I believe that I did say that I had collected them, which is typically what we were doing at that point.
Now, since that time, have you have an opportunity, or did you have an opportunity to go back and review files to make any determination whether that was done or not?
Yes, sir, I did.
Okay. Upon reviewing, again, your files, were there any the testimony that you gave on yesterday with reference to X-rays, was that testimony correct?
That was not correct, no.
And could you just tell what did you do, how did you make that determination that the testimony that you gave on yesterday wasn't correct?
Basically, what I realized on my way home was that there were no X-ray images saved in my review folder that I brought with me. And so I was concerned about potentially not releasing them for discovery or not actually having X-rays, because we didn't, at that point in Denton, we didn't always X-ray cases. We did on most of them. And so as soon as I got home, or on the way, I stopped and looked in my folder. And then I got home and logged in remotely to check the electronic folder, and there were no x-rays in our case folder or in the discovery folder for this case. And as soon as I got into the lab this morning, I logged into our x-ray server and there were no cases there. So at that point, I realized that there are no actual x-rays of this material.
Okay. And based on your review, and when you realize that you had made a mistake, did you notify anybody?
I immediately notified my immediate supervisor and the head of our legal training person here at the center, and told them what had happened and got some advice on how to proceed.
I'll pass it.
Dr. Cervello,
Yes, sir.
after speaking to your supervisor and the other individuals there at the University of North Texas, what did you do with the information that you had testified incorrectly?
As soon as I was done talking with them, I drafted a letter to send to your office just to inform you of the mistake that I had made, because I didn't want to sit on this. I understand the importance of getting it to you.
Yes, doctor, we appreciate that. And about how much longer was it after you sent that we contacted you to let you know to appear by Zoom?
Within a couple of minutes, I got the first email.
All right. Now, in regard to the x-rays in this case, why would you not have taken x-rays in a case like this one?
So generally when we're looking at burn material, we're looking for, there's more than we have. Here we had a limited amount of fragments, I think probably less than 30 small pieces of bone. There's not a lot of material stuck to it. It's fairly clean. It's easily recognized as bone. And so there's really no suspicion of it being anything else. Often when we have thermally damaged bone, there'll be a large mass of stuff that comes in, and we have to separate out what are bone fragments, what are pieces of wood, what are pieces of tire, foam, all the other kinds of debris that might be present with burn material. And that wasn't really an issue here. And then we usually use it to search for things that we don't expect to be present. So it really, given what we were presented with in this case, I'm not surprised that I didn't x-ray it, because it was very clear with what I had.
All right. And you testified yesterday that your determination of human versus non-human bone fragments is largely the result of observations, correct?
That is correct.
All right. And I think it's fair to say you made a mistake in believing that you'd taken x-rays.
That is definitely a fair assessment.
All right. However, does the lack of x-rays in any way change your opinion about the nature of the bone fragments we discussed yesterday?
No, it does not.
That's the way to show it.
That's just follow up. Excuse me. Doctor, you remember on yesterday that I even asked you about whether or not a radiologist looked at these bones, correct? You remember?
I remember, I thought you asked me if I look at it like a radiologist. That's how I interpreted the question yesterday. I'm not a radiologist.
Oh, I'm sorry. You're not a radiologist.
No.
Now, you testified that in some cases, items would be x-rayed, correct?
This is correct, yeah.
Okay. And when the x-ray, if you do an x-ray on it, are you looking for certain things on that x-ray that will help you, say, in the decision-making process?
You broke up a little bit. So are you talking about cases such as this one when we're dealing with thermally damaged bone?
Yes.
Because So on thermally damaged bone like this, and again, it's the amount of material that you receive varies from case to case, but often we get large bags of material, and it'll be a mixture of fragmented bone and everything else that could potentially come out of a fire scene. And so we have to, before we can really say anything about the bone fragments, we've got to make sure we isolate those from everything else and sort into different materials. And so we will use that because bone is relatively dense, and so it's going to show up brighter, for lack of a better term, on an x-ray than something that's not as dense like wood or foam. You know, rocks are dense, and so they might show up more dense on an x-ray. And then we also look for suspicious metal fragments. So often on burn cases, you're looking to see if there's potentially something that could be a projectile that you could recover. And so that's, on burn material, that's typically how we use x-rays. Does that answer your question?
Yes, partially. Let me ask you this question. In terms of, say, human bone, or notwithstanding a person's, say, race, are all human bones in terms of, are they all similar, notwithstanding which part of the world you're in? Are all human bones technically the same types of things in all human bones? Are they uniform?
Are you asking if the skeleton is generally the same across all people?
Correct.
I mean, in general, there's variability, but we all have roughly the same parts. You know, some people have extra little bones that might form in tendons, or extra little bones that might form in the sutures of their skulls, but you know, and the shapes might be slightly different from person to person, but in general, we all have essentially the same major parts.
Yeah, parts, but things like density, how dense they are, and when you look at
That's going to be something that varies from person to person as well. You know, your age can affect your bone density, the sex of an individual might have an effect on it. General health like that. That's something that's very, very broad. You know, someone that's very old and osteoporotic, or they're not going to have bone that's quite as dense as someone that's younger and has healthier bone. But that's part of that variability that you look at, but it's still recognizable as bone.
So in a case you said where there's some thermal damage to a something that you consider bone, so you would just rule out the x-rays and always not x-ray them, or would it vary just based on the situation?
The main question on this, there wasn't really any doubt that what I was looking at was bone. The question was, is this human bone or non-human bone? And that is a process that involves, gross examination and examination under a little bit of magnification, like we talked about yesterday. Shooting an x-ray of those bone fragments really wouldn't have given me any more information as far as is it human or not.
Now, when you look at them through a microscope, I know that some microscopes that you're allowed to take photographs of what you're looking at.
Mm-hmm.
Was that the type of microscope that you were using?
No, I didn't use a microscope on these. I just used we have a lamp on our workbench where we do all of our analyses. Each of our workbenches has a lamp on a long arm that has a magnifying glass in it, and then there's a separate handheld magnifying glass that we can use to look at detailed stuff. And those are the kind of items that I used. So.
Oh, okay. So it wasn't a microscope, it's just like a looking glass.
No, gross, looking glass. Gross observation and, low magnification under under a looking glass or under a magnifying glass.
Pass it.
Nothing.
All right, thank you, doctor. Stay well.
Thank you, sir.
Can I turn that thing off?
Yeah.
Thank you, Deputy. All right, next witness, please.
Your Honor, at this time, the defense rest,
Stay rested closed session.
Close.
we close,
All right.
and we have a motion to take outside the court.
Right now? Okay.
Yes.
Just take him into the hallway. You don't even have to go back, unless you really need to go back to the room.
All right, Jerry.
So, sorry.
welcome to the one of the thing.
No, we want to enjoy his service. I set you up for that one, sorry about that. I said you could go to the room, didn't I? All right, ladies and gentlemen. All right, it's cause number 2022 CR 8637, State of Texas versus Andres Tarnava III. Charge of the court. Members of the jury, the defendant, Andres Tarnava III, stands charged by indictment with the offense of murder, alleged to have been committed on or about the 26th day of April 2021 in Bexar County, Texas. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Individual means a human being who is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death, or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment, and not so remote that the prosecution of the offense is barred by limitation. There is no limitation period for the offense of murder. The indictment in this case was filed on September the 7th of 2022. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provision of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that the evidence was obtained in violation of any provision of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. Under the laws of the state of Texas and the United States, before police may stop a moving vehicle for a traffic offense, the officer must have a reasonable suspicion based on articulable facts to believe that the driver has committed some offense against the traffic laws of the state of Texas. Reasonable suspicion exists if the officer has specific, articulable facts that, when combined with rational inferences from those facts, would lead him to reasonably conclude that a particular person is, has been, or soon will be engaged in criminal activity. This is an objective standard that disregards any subjective intent of the officer making the stop and looks solely to whether an objective basis for the stop exists. A person commits an offense if the person operates on a public highway a trailer that does not display a registration insignia, i.e. a license plate, that establishes that the vehicle is registered. Therefore, if you find that the officer who stopped defendant's vehicle did not have a reasonable suspicion based on an articulable facts to believe that defendant committed some offense against the traffic laws of the state of Texas, namely, failure to properly display a license plate on the vehicle's trailer, or if you have a reasonable doubt thereof, then you will wholly disregard the evidence obtained from the stop or of the defendant's vehicle. You are instructed that a statement made by a defendant is to be wholly disregarded and not to be considered for any purpose whatsoever by the jury if the following three circumstances exist. Number one, the statement is given as a result of custodial interrogation. A person is considered in custody only if, based upon the objective circumstances, a reasonable person would believe he was restrained to the degree associated with a formal arrest. Custodial interrogation is defined as questioning initiated by someone in the role of a law enforcement officer after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Custodial interrogation exists when a reasonable person would have believed he was not free to terminate the interview and leave. In determining whether a person is free to leave, the following factors are considered. Whether probable cause to detain the person existed at the time of questioning. Probable cause exists when facts and circumstances within an officer's knowledge and about which he has reasonably trustworthy information are sufficient to warrant a person of reasonable caution to believe that an offense was or is being committed. The subjective intent of the officer or functional equivalent of a law enforcement officer doing the questioning, the focus of the investigation, and the subjective belief of the individual being questioned. And this is two. Prior to making such oral statement, the accused was not given the following warnings by the person to whom the statement is made. A, that he has the right to remain silent and not make any statement. B, that anything said by the defendant will be used against him at trial. C, that the statement will be used against him in court. D, that he has the right to terminate the questioning at any time during the interview or questioning. And E, that he is entitled to the services of an attorney, his own, or if he is unable to employ one, a court-appointed attorney to advise him prior to and during any questioning or interrogation. 3, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. A defendant's statement may be considered involuntary when there is overreaching in the form of official, coercive conduct by the person doing the questioning of such a nature that any statement obtained thereby was unlikely to have been the product of an essentially free and unconstrained choice by its maker. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such a statement for any purpose, nor any evidence obtained as a result thereof. You are instructed that if there is any evidence before you in this case regarding the defendants having committed offenses or acts of misconduct other than the offense alleged against him in the indictment in this case, you cannot consider said testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or act of misconduct, if any were committed. And even then, you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, if any, of the defendant, if applicable, and for no other purpose. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 26th day of April 2021 in Bexar County, Texas, the defendant, Andres Tarnava III, did intentionally or knowingly cause the death of an individual, namely Marisol Klingelhofer, by shooting Marisol Klingelhofer with a deadly weapon, namely a firearm, or the defendant, Andres Tarnava III, with intent to cause serious bodily injury to an individual, namely Marisol Klingelhofer, did commit an act clearly dangerous to human life that caused the death of Marisol Klingelhofer by shooting Marisol Klingelhofer with a deadly weapon, namely a firearm, then you will find the defendant, Andres Tarnava III, guilty of the offense of murder as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Andres Tarnava III, not guilty of the offense of murder as charged in the indictment. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, or Twitter, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the grand jury indictment is not evidence of guilt. It is a means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in determining whether the defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. After you have retired to your jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by signing the same as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed thereby. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right, by any word or any act, to indicate any opinion respecting any matter of fact involved in this case, nor whether the defendant is guilty or not guilty. The court is not intended to express any such opinion, and if you have observed anything which you have interpreted or may interpret as the court's opinion upon any matter of fact in this case, or of whether the defendant is guilty or not guilty, you must wholly disregard it. You are instructed that the statements of counsel made during the course of the trial or during argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied, beyond a reasonable doubt, of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are instructed that you are not to let bias, prejudice, or sympathy play any part in your deliberations. Suitable forms for your verdict are hereto attached for your convenience if you desire to use the same. But such forms are not intended to suggest to you in any way what your verdict should be. And you may or may not, as you see fit, make use of the same. However, your verdict must be unanimous, in writing, and signed by your presiding juror. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty, and nothing else. After you have retired, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your inquiry to the court in writing. If the jury wishes to communicate with the court, they shall notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and shall be submitted to the court through the bailiff. Respectfully submitted, Judge Kevin M. O'Connell, Judge presiding by assignment for the 226th Judicial District Court of Bexar County, Texas. State.
May it please the court. Mr. Cox. Members of the jury. When I see her in hell, I'm going to fry her ass. I would do it again in 1,000 years. I would do it again and again. Those are his words, not mine. I think the evidence in this case shows pretty clearly what happened. This defendant, mad that Marisol Klingelhofer had stolen something that belonged to his departed father, social security number, ID, something like that, got mad. He couldn't get her over to his place, so he went and found her where he knew she was hanging out with friends. He walked up to the car she was sitting in with Ruben Arguello, and he shot her twice in the face with a .25. After he shot her and she was dead, he dragged her from that car by the ankle over to his maroon GMC Yukon. He threw her in the back. He drove her home. He dumped her body on a burn pit, and he burnt her. He used motor oil as the accelerant. And he burnt her until all that was left were bones that were indistinguishable from the animal bones around them, and two charred human bone fragments that Dr. Cervello was able to identify. That's what happened in this case, and that's why we're here. There's been a lot of talk about the investigation, about the other things going on around this case, but that's why we're here. So I'd like to talk to you a little bit about the law in this case and some of the more tricky elements of this jury charge. After I'm done, Mr. Cox and Ms. Garza will speak to you, and then finally, Mr. Jordan will give you the last word in this case. But I'd like to talk about this charge. And one thing really quickly, in regards to that confession, there are a number of discs here that contain pieces of that confession. You saw, because of the error that the state made, it was our fault, that the Miranda warning had been excised unintentionally from that original confession. We now have a complete version The only things removed from it are things that are muted for evidentiary purposes, but states 103 is going to be the one to ask for. If y'all want to watch the confession, if you want to see anything from the defendant's statement, ask for states 103. That'll be the complete thing. Now, I'd like first to talk to you about the on or about language. And the way the law is in the state of Texas, on or about can mean any time anterior to the presentment of the indictment, which means before the indictment is signed by the grand jury, back to the beginning of the statute of limitations. There is no statute of limitations for murder. So, as long as the state proved that this offense took place before September 7th, 2022, the on or about language is legally satisfied. We've done more than that. We've proved to you that this happened in late April of 2021, on or about April 26th. There's a little bit of disagreement. Some of the civilian witnesses who saw it happen aren't entirely sure, 27th, 28th, those exact days, and law enforcement wasn't involved until a month later. So there's a little bit of wiggle room, but we proved that it happened on or about April 26th of 2021. The other thing I'd like to talk to you about is these two sections about the voluntariness of the confession and the legality of the stop. So, you received instructions that an officer must have a reasonable suspicion in order to pull somebody over for a traffic stop. And that's right here in your jury charge. There's been a lot going back and forth about pretext stops, about maybe a briefing that did take place earlier that day, whether officers were looking for a reason to pull the defendant over, and I'll tell you they were. All of the testimony from the stand says they were. But this instruction tells you that the question is an objective one. If an officer has a valid reason to make a traffic stop, then the stop is valid, no matter what the underlying reasons are. And in this case, they stopped the defendant for failing to display a rear license plate. It was a valid traffic stop. And it was a valid arrest. Which takes us to the question of the confession. Now, there are three circumstances that the jury instructions talk about. They talk about whether the defendant was in custody, whether the defendant was Mirandized, and whether the statement was voluntary. Now, I will tell you, the first question is, there is no question. He was in custody. He was under arrest. He was at the sheriff's office. He was not free to leave. This defendant was in custody when that interview took place. He was also Mirandized, and this jury instruction gives you the 5 questions that have to be asked to satisfy Miranda. Now, those questions don't have to be asked verbatim, but they have to ask everything in those questions in order for Miranda to be satisfied, and you can watch it on the video. You already have. The defendant was Mirandized before he said anything of substance. So the only question that's left is the third one, and that's whether or not the defendant voluntarily waived his Miranda rights. Now, the question about whether the defendant voluntarily waived his Miranda rights is not a question of how long he was detained prior to being given those Miranda rights. It's not a question of whether the police conducted other searches while he was waiting. We agree in this case, there is no dispute that 6 hours went by, a little bit more than that, between when the defendant was pulled over and when he was Mirandized. That's not the question. The question is whether he was capable of voluntarily waiving his Miranda rights when the interview took place. And you determine that by looking at the video and how the defendant was doing and all the evidence you have. You look and see if the person you saw on the video was incapable of waiving his rights, or the person was capable of it, whether he was all there, whether he was lucid, talkative, coherent, whether he remembered what happened as he talked, whether he showed emotion but restrained his emotion, whether he was in control of what he was doing and what he was saying when he waived those rights. Did you see a person who was entirely broken, unable to waive his rights and voluntarily make those statements? Or did you see someone who just woke up from a nap? Now, if you find that the confession was involuntary, if you do find that he was not able to voluntarily waive his rights, that's not the end of the case. The result of you finding the confession involuntary would be that you need to disregard everything that was said in that statement and any evidence that was obtained because of the statement. Now, in this case, there was no evidence obtained because of the statement. As you've heard over and over again, all of the evidence in this case that the Rangers collected, all of the witness statements, all of the physical evidence, every bit of that evidence was obtained prior to them conducting that interview. So, if you find the confession was involuntary and you decide to disregard it, you still consider all of the evidence that's before you in this case. Now, I believe that that is all of the things I'd like to talk to you about with regard to the charge. I'd like to thank you for your patience this week, and thank you.
Defense?
May I please report?
Yeah.
State. Good afternoon, ladies and gentlemen. Thank you for your patience, for your attentiveness, and for paying close attention throughout this entire process. I know it's been a long couple of days, and I know you have been paying attention, writing notes, focusing on the witnesses that have come forward and testified. This is almost the end of the case. This is the time where the judge will hand you the case and where he will hand you the road. You all will become judges, and what that means is that every single person that sat on this chair, you will now be the judge of their credibility. You will decide if their testimony was credible. You will decide if they were truthful, and you will decide if the weight of the evidence was credible. So when the judge hands you the case, you will now become the judge. You will judge the credibility of all the witnesses that came in and testified, including all the law enforcement agents that came in and testified, including all of their actions or lack of their actions. You alone, individually, will be the judges of their actions. With that said, when you go and you deliberate, you will be handed the charge of the court, as the state mentioned. And so I'm going to go over certain portions of that with you, highlighting some of the portions that I would like you to focus on. And as the state focused on, I'm going to also be focusing on the stop. He focused on the reasonable suspicion of the stop. Law enforcement, they talked a lot about that there was reasonable suspicion of the stop. When you go to the back, you're going to have the definition of the reasonable suspicion. The judge read everything here. He read everything that you're going to have in order to make a decision, in order to render a verdict. You're going to have everything here. All the law, you're going to have it with you. You're going to be able to tear it apart, pick it apart, and be able to make a decision. The state of Texas earlier stated that there was reasonable suspicion to stop the vehicle. However, if you go back and you listen, I know that you were listening. If you go back and you reflect on the statement made by Deputy Garza and other deputies, when they went to the briefing, Deputy Garza clearly testified that they were going to find a reason to stop Mr. Tarnava. They never said that there was probable cause. When Mr. Tarnava was driving off of I-35, and they were at that briefing, he clearly testified and he said they were going to find a way to stop him. They never said that there was probable cause. They were going to find a way to stop him. So when you go back and you go to that section where it states, under the laws of the state of Texas and the United States, before a police may stop a moving vehicle for a traffic offense, the officer must have a reasonable suspicion based on articulable facts to believe that the driver has committed some offense against the traffic laws of the state of Texas. Remember what Officer Garza said. They were going to find a reason to stop. Did they create probable cause? Did they make it up? Because in that briefing, they said they were going to find some reason to stop him. That's what he testified to. I also want to talk about there was a lot of mention about the interrogation, about Mr. Tarnava's interrogation and his statement. And it is true, there has to be 3 prongs that need to be satisfied. And one of them is the statement, when the statement is given, it has to be under custodial interrogation. And I think we can all agree that Mr. Tarnava was in custodial interrogation. That's the first one. The second one, prior to making such oral statements, the accused was not given the following warnings by the person to whom the statement is made. That means that, was he given his Miranda rights? We had that whole issue where they had to get another DVD made so that you guys could hear that the Miranda warnings were given to Mr. Tarnava. So he was given his Miranda warnings. That's the second prong. The third prong is where the state of Texas and I disagree a little bit. It states, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. The state of Texas position is that Mr. Tarnava freely and voluntarily waived those rights. However, it goes on and it states, a defendant's statements may be considered involuntarily when there is overreaching in the form of official, coercive conduct by the person doing the questioning of such a nature that any statement obtained thereby was unlikely to have been the product of an essentially free and unconstrained choice by its maker. So, Mr. Cox focused a lot on where Mr. Tarnava was during the entire time of the interrogation. He was in 2 separate rooms. We really don't even know how long he was in that other room. We think he was in the room probably an hour and a half, maybe a little longer. And in the video that you saw, we got it down to maybe 4 hours. So 4 hours by himself in handcuffs, and in the other room, maybe an hour, hour and a half. So total, maybe 6 hours without anybody there. We do know that there's an officer outside. So they want to claim that he's comfortable because he's asleep. Well, he has nothing else to do. He's a big guy sitting in that chair. I don't think that's comfortable. He has nothing else to do but to sleep. He can't leave. He has an armed guard outside. He can't leave. He can't use the phone. He can't get any water. He can't get anything to eat. So he's not free to leave. He's been there. They don't know if he has any medical issues. He doesn't know if he has any medical conditions. He's in another room first. They transport him to the other room while they're searching his home, searching the vehicle. Then they finally come in, and to the law enforcement agencies, they feel that that's okay. It's not. So you have over 6 hours of him being in that room, unable to leave, unable to use the phone. He's not comfortable. The only thing that he can do is sleep. They make it a point to say that he's okay because he's sleeping and he wakes up. He has nothing else to do but to sleep. So when you look at this definition, the fact that he is in there for these 6 hours and then they come in and they start asking him questions, you could analyze that, and it could be that the questioning of such a nature is obtained, thereby was unlikely to have been a product of an essentially free and unconstrained choice by its maker, because of the amount of time that he was in there, and he was not free to leave. It was not voluntary, because the amount of time that he was in there. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have any reasonable doubt thereof, you shall not consider such statement for any purpose nor any evidence obtained as a result thereof. Thank you.
May it please the court, counsel for the state, members of the jury. This part of the trial is referred to as summation or closing arguments. This is where the lawyers kind of highlight what we felt that the evidence showed. As the judge indicated, that what the lawyers say is not the evidence. At first, we'd like to thank you for your being here throughout this trial and being attentive to everything that has happened in this trial thus far. Now, as the defense attorneys, we're placing the situation where the state had spoken to you earlier, and then when we're seated and we can't say anything else, they'll come again and they'll talk to you. Now, so we have to kind of respond to what they said thus far and kind of anticipate what they're going to say when we're seated and we can't come back and say anything else to you. Sometimes they'll come and they'll point a finger at as the accused and maybe hit on the fist on the table and tell you this is a clear case. That brought you everything. The only thing you need to do is go back into the jury room, come back with a swift verdict of guilty. In that their interest is just providing facts and justice. The problem is that your job is to review all the evidence, consider what they brought forward, and also anything that was lacking. The burden never shifts. The burden never shifts. Their responsibility to provide the evidence and prove every element of this case beyond and to the exclusion of every reasonable doubt. And if they fail to do that, it's not a situation where you have to grapple with that. If they fail to do it, your verdict has to be one of not guilty. That's the law. That's the law. Now, they mentioned already the Prosecution Act. Well, you want to look at the charge and take it back with you, and I think the words that the prosecution used, that this is a tricky charge. And this is a law that's given to you by the judge. Now, they refer to it as a tricky charge. Why? Because it's the law, and if something doesn't go along with maybe their theory or their way it should go, then the law becomes tricky. They mentioned already about the investigation. The defense spent a lot of time on the investigation, talking about the way the case was investigated. The ends of these cases, any trial, doesn't justify the means. So it's not a situation where you can investigate the case any kind of way you want to, and at the end of the day, as long as you convict somebody, all is well. We anticipate, they're gonna show you photographs. They're gonna probably put the interview back on the screen, ask you to look at it in terms of their positioning on this case. But the investigation is important too. And there were witnesses. Some eyewitnesses that were at distances where they indicated that they saw some things and didn't see others. Some witnesses that testified that they were under the influence of meth. That's all a part of the case. You can't separate things and just say, well, no, it doesn't matter. You gotta look at it all. At the inception of this investigation, there was an issue. One of the issues was that not one of the eyewitnesses that took the stand ever said that, well, I saw something and I reported it. Not one. Secondly, with reference to the investigation, there was kind of a rush to judge. Why? Because at the very inception, you have a situation where the two rangers that testified, Ranger Peters and Ranger Perez, give different versions of what happened at a briefing that happened the same day that my client was stopped and arrested. These are officers, not only officers, rangers, all kinds of experience. They get up on the witness scene and they're looking at their notes, their case file. It's their case, it's their investigation. And almost every time a question was asked that wasn't asked by the prosecution, they didn't recall. Oh, yeah. What time did you leave the location? I don't recall. What time did you get to the location? I don't recall. Did you write it in your note? I don't recall. Look at the notes, always not there. I don't recall. When they say to ask a question, oh, sure. When there was something to their event, oh, they would say it. Anything else, they didn't recall. The problem, and the state may come and tell you, well, no, that's not important. I think everything in the case is important. ask questions about the evidence law. They don't recall. Did you give, during that briefing, the briefing? They don't recall. They don't recall how long it was. They don't recall, except for maybe 1 or 2 officers, how many were there. They don't recall what instructions were given to them. They don't recall. They go out and they say, they claim that they execute search warrants. They don't know how long it took them. Not sure what time they get to the next locations. They don't recall them. Those things are important. And why? Because when you look at the instructions, and there's issues in terms of whether or not a statement that was taken, and whether that process was a process that someone may have overreached. The time frame is important. The lead ranges, they don't ask whether the client had been magistrated. They don't ask how long he'd been in a room, whether that room was air conditioned or not, whether it was hot. They don't ask. I submit to you because, no, that's not important. What's important is to get a statement. Now that's important, to get a statement. The ranger on the stand, under oath, is asking you to say, well, it doesn't matter whether the person's under the influence or not, or drugs, or alcohol, it doesn't matter. Why? We need a statement. So what do? They go out and they do other things, and there was testimony from the Rangers. There are other Rangers. They have people to help. Have folks that go and take the evidence, and also take a question, take a statement. To have someone sit for hours and hours, and we don't know what those conditions were, mostly. We'll take a statement. It's part of it to kind of wear a person down so they're more susceptible giving a statement. Standard is And the standard will always be proof beyond a reasonable doubt. Proof beyond a reasonable doubt. This morning we had the doctor that talked about the x-rays, and he mentioned that she testified under oath about his observations referenced x-rays that was a part of his decision-making process, and he realized that he had made a mistake. People make mistakes. People make mistakes. I don't know exactly what the state is going to say to you when I see it. They may wheel the barrels back and talk about those. But what I do know is that this case, based on the evidence, was targeted. And part of that targeting was to build the evidence against my client. Officer Gardner, I believe, who was at that briefing, and his testimony was that he was told that they needed to find a reason to stop the people. It's not my words. Those are his words. I submit to you that in terms of the statement that my client gave, that there were issues about the time, the timing of it, and the officers' repeated responses of, I don't recall. I submit to you that that statement, based on that, and based on the law, the charge, in the instructions, to be disregarded. state tells you that, well, even if you disregard it, there was nothing, no other evidence that was gathered based on that, or even based on that stop. You see, state exhibit number 25 and 26, which appears to be some type of handgun that comes from that interrogation. I submit to you that when you consider all the evidence, the lack of evidence in the way that evidence was actually gathered, that even if the state pounds on his desk and points at my client, that the only verdict that's just with all those issues is a verdict of not guilty. Thank you very much.
Mr. Jordan,
May it please the court.
please.
Opposing counsel. Good afternoon, ladies and gentlemen. At the very beginning of this trial, during opening statement, I told you that this case, in a nutshell, would be about three things. And those three things remain as true then as they do now. I told you that this case was about him shooting her and killing her, burning the remains, and him being guilty. And all of the evidence in this case has proved that beyond a reasonable doubt. All of the elements that we discussed ever since jury selection have been proven to you beyond a reasonable doubt. Back in opening statement, the state also gave you a sort of roadmap of everything that we expected you to see throughout the course of this trial. I told you the witnesses that would come to talk to you, in what order they would come to talk to you, and all of those things have come true. All of the promises that the state made to you have come true. This case has been proven beyond a reasonable doubt, ladies and gentlemen. You heard from the victim's daughter, Marisol Klingelhofer's daughter, right? And she told you when she made the report of her mom being missing. You heard from the two officers who started receiving those anonymous informants, as well as the witnesses that came forward regarding the disappearance of Marisol Klingelhofer and how she would never be found. You heard about the traffic stop. You heard from the rangers. You heard from the anthropologist that confirmed those two bones that I told you they found were human remains, where the witnesses say they would be found. And you also heard from the defendant himself, like I told you you would, throughout the course of that interrogation. Beyond a reasonable doubt, ladies and gentlemen. This case, since the very beginning, has been about those three things, right? I agree with Mr. Cox to this point, and I told you this even since jury selection, right? Our duty as prosecutors is to see that justice is done, right? And we brought everything to you that we could to show you beyond a reasonable doubt exactly what happened in this case. And the reason I say everything that we could is because obviously there were things that we could not. Things like this firearm, right? And we know what happened to that firearm. Things like DNA from that blood, that presumed blood that was found in the back seat of that GMC, in that back trunk area of that red GMC, right? But let me remind you all the way back to jury selection when we talked about who decides when, how, and where a crime takes place, right? Do you guys remember that? The person committing the crime decides, right? Who decided to commit this crime? Andres Tarnava. Who did away with that gun? Andres Tarnava. Who did away with that body? Andres Tarnava. Andres Tarnava, the same person who hoped that by his brutality and by his intimidation, no witnesses would come forward and talk about the crime that he kept bragging about for days after he had committed it because he had zero remorse for what he had done. We brought to you the barrels, ladies and gentlemen, because I think it's important. If you recall, when Ruben was up there testifying, the threats that Andres Tarnava was saying to him was that he had cut her up and he better not say anything or he would kill him. Right? That's his words to Ruben. We brought you the barrels so you can get a size comparison, right? So you can see them and see their size. And you tell me, when you go back there and deliberate, if you believe that a whole body could be fit in those barrels and then burnt so severely that only 2 bones could be recovered. He was making very credible threats to those witnesses. Now, regarding those witnesses, ladies and gentlemen, we talked about that too, even since jury selection. We talked about perfect witnesses, right? We're not saying that the witnesses that came forward to testify for you are perfect people. We're not, and the state of Texas is not sponsoring that to you, right? We don't get to choose who sees a crime. They are the people that they are, and they are who they are. We don't get to choose, because like we talked about with who chooses where and how a crime is committed, we have nothing to do with that. But we brought you those eyewitnesses so they could give you the accounting of what they saw that mid-April day in 2021. And their stories were all consistent. They were consistent to each other's. They were consistent with the eventual confession that you hear from Andres Tarnava. To the T. Ruben ran away. Multiple shots. Green vehicle. 25 caliber handgun. Chrome in color. Small. It looks small in his hand. Everything is just consistent from point A to Z. Because it's the truth. You don't have to like those witnesses. We're not asking you to like them, but they were telling the truth, and that is obvious. They didn't come forward. I wish that they had. That would be the right thing to do. I'm not justifying why they didn't come forward, but they saw what they saw. There's also the matter of the voluntariness of the confession, and that was a point of debate throughout the course of the trial. It was voluntary, ladies and gentlemen. That's the point of the Miranda warning. 6 hours. It's a long time, but relatively not that long when you consider into account, like Ranger Peters told you, that it can be kept in custody for up to 48 hours before being presented to a magistrate. That's worst case scenario, right? A maximum of 48 hours, not to exceed 48 hours, right? The question is whether the delay is reasonable. And we know what they were doing. They were gathering all the evidence that they could before they talked to a suspect in a murder investigation. We want them to go into that interview room armed with facts and evidence that they can confront a person intelligently with, right? They weren't out there twiddling their thumbs and trying to wear down his resistance or what have you. They were gathering evidence. Evidence that can go away, evidence that can spoil, right? Like bodies and things that are burnt, things that can be moved. Right? So it's important. It's super important. Vehicles can be moved. Super important. Likewise, you can see in the video that the defendant spends most of those 4 hours in that interview room sleeping. He's asleep, right? When the Rangers come in, they ask him, "Are you okay?" Golden opportunity to say, "No, I'm not." They read him his Miranda warnings, one after the other after the other. He nods his head. He says, "Yes, I understand." At any point, that's the point of the Miranda warning. He can say, "I don't want to talk to you. I want my attorney." He doesn't do that. It's voluntary, ladies and gentlemen. And even then, for about an hour, he claims that he doesn't know who Marisol is, and he's giving off this whole tale until he eventually confesses, right? There was no degrading of his ability to resist or anything along those lines. That was voluntary. It was a voluntary confession, ladies and gentlemen. He even goes as far as to give you the motive as to why he does it. It was so voluntary, in fact, that he tells you why he did it and how little lack of remorse he has for doing it. He'd do it again. He said that. There should be no doubt in any of y'all's minds, ladies and gentlemen, as to what happened in this case. There shouldn't be. But let's go back to the subject of justice, right? And Ms. Garza told you this as well, while she was up here, and told you that you would go back to the deliberation room. If you recall back during opening statement, I also asked you, or told you, that at the end of this trial, the point that we are now, the state of Texas would ask you to return the only true verdict in this case as supported by the facts and the evidence. Right? Remember that our job to seek justice. Well now, that job actually goes on to you as you go back there to deliberate. Right? The ability to do justice in this case and to arrive at a just verdict supported by all the facts and evidence is up to y'all when you go back there. We try to arm you with as much facts and evidence as we possibly can for you to make that determination fair and easy for you, right? As easy as we can make it. And all of the evidence in this case, the overwhelming amount of it, all of the corroboration between it, has done that, ladies and gentlemen. So, the state of Texas is going to ask you, as I said in the very beginning, to return the only true verdict in this case. And that is a verdict of guilty. We live in a society, ladies and gentlemen, of consequences, right? A cause and effect. And when you do something, you have to face the music, right? Like the saying goes, he who reaps the wind has to be prepared to reap the whirlwind. Well, now it is time for Andres Tarnava to face that whirlwind which he himself created. So find him guilty. And I assure you that when you return that verdict of guilty, you will not be telling this defendant anything that he doesn't already know. Thank you for your time.
Hi, ladies and gentlemen, we await your unanimous verdict. All right for the jury? so long. That same guy? Make a little walk of shame again?
Oh, did he have to do that?
It wasn't his fault. I said, if you need to use the restroom, go. But then, for some reason, they brought like 11 of them in. It was like an empty seat. Poor guy. Okay.
All right, for the jury.
Okay, have a seat, everybody, please. All right, ladies and gentlemen of the jury, my understanding the jury has reached unanimous verdict.
We have, Your Honor.
Could the foreperson please hand the verdict form to the bailiff? Mr. Tarnava, you wouldn't mind, sir, could you rise with your lawyers? This cause number 2022 CR 8637, the state of Texas versus Andres Tarnava III. Verdict form reads, we, the jury, find the defendant, Andres Tarnava III, guilty of the offense of murder as charged in the indictment, signed by the presiding juror. Does either side wish to have the jury polled?
No, Your Honor. No, Your Honor.
All right, have a seat, thank you. All right, ladies and gentlemen, what that means is that your service is done. So all the things that I told you about earlier about not talking and not, you can do all that if you want to, or not if you want to. I must admit I'm going to miss you. I've kind of gotten used to you. Now you don't have to say, Judge, we're going to miss you too. I completely understand that you want to get your belongings and get the heck out of here. But I will say, not one of you were ever freaking 5 minutes late. Not even 5 minutes. You never made us wait. We made you wait. You didn't do that to us, that's for darn sure. You came and you did your job. I don't think anybody ever assumed or told you anything about it being an easy job, because it's not, now you know it. But you did your jobs, you ought to be proud of yourselves. All right? So with my thanks, with their thanks, with their thanks, with everybody's thanks, I release you from all of my prior instructions. So you, like I said, you can talk to anybody, your family, your friends, whatever, if you want, or not. That's completely up to you, okay? Just if you're interested, what will happen now is there will be, because Mr. Tarnava has decided to go to the court for punishment, the court will not be me, it will be Judge Meza. All right? So she will do what is called a pre-sentence investigation, and they will delve into Mr. Tarnava's background. Everything he's ever done in his life, basically, is in a report, and then they will talk to Marisol's family and things like that, and compile this big report, and then she will decide what the appropriate thing to do with Mr. Tarnava is, okay? So that will come from Judge Meza at a different time, okay? All right, just in case you guys were wondering about that, all right? So with my thanks, God bless you. Take care of yourselves. It's been a pleasure meeting you, all right? All right, for the jury.